Data protection and privacy teams are under more pressure than ever with new laws, AI oversight, data breaches, and the constant expectation to do more with fewer resources.
That's why Stoddart built a modern privacy and data protection management platform powered by Arc Intelligence. It unifies your tools, automates the work that slows you down, and surfaces what matters most right when you need it.
From guided quick actions to our intelligent assistant, Ask Arc, you get credible, contextual answers backed by expert research, not generic AI guesses.
Finally, privacy that works the way privacy pros work.
Learn how TrustArc helps teams move faster with confidence at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.
You're listening to Serious Privacy by TrustArc. Please welcome our hosts, Paul Breitbarth and Kay Royal.
In our last episode of 2020, we discussed the Canadian Draft Privacy Law, Bill C-11, that should have ensured the complete modernization of privacy rules, at least at the federal level. However, the recent parliamentary elections threw a spanner in the works, and as yet it is unclear what will happen with the federal data protection reform. However, in the meantime, the province of Quebec, the main French-speaking part of Canada, for those of you who don't know, has approved its own new data protection law. Quebec was originally the first jurisdiction in North America with an omnibus privacy law in 1993, and now seems to have surpassed every other jurisdiction in North America by passing a very GDPR-like bill. So we welcome back our Canadian data protection experts to discuss these developments with us. Constantine Karbaliotis of Innovation and Jenifer Stoddart of Fasken Law Firm, and also former Privacy Commissioner of Canada. My name is Paul Breitbarth.
And I'm Kay Royal, and welcome to Serious Privacy. Hello again, my Canada peeps. How are y'all?
We're fine.
We're getting cold.
This is much better than the last time we talked, right? That was almost a year ago. Much, much better time this time.
At least the borders are open now.
Yes, there's that.
That is absolutely true. So,
yeah, and it's still above freezing, so that's very good.
You know, we keep
that's good.
crossed.
Yeah, I don't like snow. Although Paul isn't. Where is Paul today? I think I need a hashtag. Where in the world is Paul?
Well, yes, with the traveling starting again, you may need that hashtag again. I am currently speaking to you from Sali in Senegal, which is just outside of Dakar. And it's the time of the year again where I'm teaching a course for the International Committee of the Red Cross. We spoke about that during the summer episodes. And here I am in Dakar, or near Dakar, at the Red Cross delegation, providing another training course in French this time. And it is a balmy 36 degrees Celsius here right now at 4 in the afternoon, which is around 95 Fahrenheit.
Okay. Thank you very much for sharing that.
I'm literally melting right here.
Whereas that would be cool for Arizona. So, okay, unexpected question. Are we ready?
Yes.
We're never ready.
Always ready.
I got a good one. What do you want to say? What do you want to say when someone asks, what do you do? Ooh.
What, right now?
Yeah. If someone was to come up to you, Jenifer, and say, what do you do?
What do I do? I do a lot of things.
What do you want to say?
That's what I want to say at this point. I used to be kind of puzzled because when I had the title Privacy Commissioner of Canada, which was a long time. And I used to think, I'll answer, what do I do? I commission privacy. But I wasn't sure what commissioning privacy meant, so I refrained from saying it.
I love it.
I think that's as good as answering as anything. I like to think of myself as a privacy instigator.
Ooh.
Yes. You know,
privacy
lighting fires in various spots and instigating stuff. But, you know.
Yeah.
I love it. I love it. Paul, what about you?
I'm recording a podcast, so leave me alone. Don't ask me questions right now.
In the sun, yeah.
Media star.
Oh, I love it. I love it. I love it. I love it. So what do I want to say when someone says, what do you do? I want to be able to say I'm an international talk show host.
Wow.
That's been my dream for a long time.
You know?
Well, it's partly true.
Well, you know, #1 privacy podcast in the world sounds phenomenal. Means we have all of 600 listeners.
Well, you're still way ahead. It's all about the statistics, right?
Exactly. So everybody share it to one other person.
Mhm.
Yeah. What do I do now? Among the many things that I'm doing now, I'm actually a part-time consultant at a law firm in Canada, a big law firm that also has international offices called Fasken. And Fasken is a leading firm in data protection with, of course, the firm that my friend Constantine works for. And so what have I been doing? I have been watching the emergence of a new generation of privacy data protection legislation in Canada. So that's
wow, which is a perfect segue.
Yeah.
No, I love it because it's a perfect segue into the actual topic as Paul introduced us. So we are talking about Quebec's new privacy law. So Jenifer, why don't you dive in and give us the highlights?
Okay, it's here, it's happening. It's technically enforced now, but parts it's set up so that parts will come in force over the next 3 years. It's basically, you could say, GDPR light. It's pretty faithful to the GDPR model, much more than, for example, California is, or C11, which was a funny stew of many things, I think. And so, the key elements of the GDPR have come to Canada.
Yeah.
That's fascinating.
And did they actually take it from the GDPR, or do you think the GDPR was just a perfect mesh of storms that a lot of countries are looking that direction and they just happen to come out alike?
No, I think the GDPR is a model, clearly a model. Quebec, as you mentioned, is our French-speaking province, therefore very closely aligned with what happens in Europe, with Paris. France has been a leader in the creation of the GDPR and its administration. So this is on purpose.
And the reason I ask is because a lot of people don't understand that. They don't understand that GDPR truly is driving laws. They're like, no, all these countries believed in privacy. It just happens to be coincidence that they're looking alike.
Oh, goodness.
Yeah.
Right?
Well, I'm sure Constantine has things to say about that. I mean,
yes, Constantine, what do you have to say about that? I'm playing devil's advocate this one, and I hadn't even finished my coffee yet.
Well, as Jenifer said, it's not accidental. It is about that magic sort of equivalence. It's not adequacy. It's really, interpreting
Essential equivalence.
Essential equivalence. Yes.
I like that.
And, so in many respects, through cross-border transfer provisions, through the PIA, privacy by design, even the fines mirror the, GDPR. And I would be surprised if adequacy wasn't something that they had an eye on in drafting this legislation. Because as Jenifer will be able to tell you, that was an issue for Quebec in the past. And I would present the California scenario, which, Californians like talking about, which is if they didn't have the NSA, could they achieve, adequacy with the European Union? I think it's much more likely and much more possible for Quebec now than it is for California.
I
that would solve a lot of issues. It would solve a lot of issues that we've been discussing for God knows how many years, especially in the context of the World Anti-Doping Association, which has its headquarters in Montreal. And that has been a big issue for the European data protection authorities. The whole whereabouts system is also hosted out of Quebec, where athletes have to indicate 24/7 where they are so that they can be checked for doping. And because Quebec never was adequate, that has always been an issue to have those international transfers taking place out of Europe. So it would be interesting to see what will happen now if Quebec really could become adequate. That would solve a lot of issues, at least for sporters.
Now we're going to have maybe the opposite problem, which will always be an issue in federal countries like, for example, the United States. Arguably, Quebec now has a good case to become adequate under European standards, but the rest of Canada, all the other provinces, all 9 of them in territories as well, and the federal jurisdiction may not be adequate currently. So, what will that make? I think, what's interesting to look in this whole saga over the years that Constantine and I have been following is that things go on. People kind of seem to muddle forward. There hasn't been, that I've noticed, any abrupt end in trade. Although I think the World Anti-Doping Agency has had some really severe issues with this. But for commercial exchanges, I think somehow there's a pragmatic will to keep on trading, just like after Schrems 1 and Schrems 2.
So, Jenifer, is that your fear that Canada will lose adequacy at the federal level?
I don't think it can lose adequacy the way things are now. I think that the European Union will keep reviewing Canada. I was looking for Canada's latest report on the website of the department called Innovation Canada to the EU. I couldn't find anything up to date. I don't know if it's my feeble research skills, but I think that there is a huge lack of movement from the Canadian government on this issue. But in the meantime, I think nothing will happen that's negative for Canada, because I think because we signed something called CETA, the Canadian-European Union Trade Agreement, this spring, it's really important to keep things flowing, including cheese, I read, and cheese is going up 8% next year in Canada. So I don't think we should be alarmed, but these are things to watch.
I'm alarmed by the news about the cheese, Jenifer. I don't want to have my cheese supply undermined here.
Yeah.
I think, data goes with the trade, and for Canada, maintaining trade with the European Union is vital. I do, however, feel that we're going to get a report card at a certain point.
Yeah.
And my concern is maybe the most Canadian analogy of our, parliamentary process is that it moves like molasses in January, is that we're going to take bloody forever. I mean, Max Schrems, thankfully, has not got targeted, Canada. We don't host the major tech companies. So there's not going to be like a...
Nobody targets Canada.
Well, we shouldn't rest on our laurels, right?
Don't throw that out in the universe. Is that what you're saying?
No.
But you're also friendly, eh?
Well, we are friendly, except, of course, if you've ever watched us play hockey, then you'll change your mind about that.
Or lacrosse.
But I think that the ice hockey is perhaps the most important sort of point.
The one and only ice hockey game I ever saw, the first one was in Canada.
Yes, and you were probably going so much for that nice Canadian image. But we're not going to get a court of justice decision suddenly killing data flows to Canada. What is more concerning is the endless time it takes to actually update our laws. And we will see some pressure, I think, because they're obliged under GDPR to review everyone's adequacy.
Yeah, and it was almost 20 years ago that Canada got its adequacy decision.
Exactly.
Mm-hmm.
Things have changed. There's this internet thing that came along. And,
And your adequacy decision is all of 4 pages, where nowadays there are over 160.
Those were the days, yes.
Oh, yeah. No, they're novels now. And, if you read any of the recent adequacy decisions and you hold it up against what we're doing, it's like, not so good.
And isn't Canada a member of the 5?
Well, that's also a factor.
Yeah. We were.
We were. Okay.
Well, I mean, it's just there was a lot of discussion about us not having been included in a recent international maneuver. But yes, we formally are, and we operationally are. I think it's diplomatically. What role do we play?
Well,
Spoken like a true diplomatic politician.
I'm not a politician.
Yeah. But you are diplomatic.
You are diplomatic.
So what is happening at the federal level? Is Bill C-11 still alive after the election, or do you just need to start from scratch?
Well, if it's alive in the way that, was reminiscent of our recent Halloween, which is to say it's a zombie waiting to come out of the grave.
That's a good analogy. That's perfect, Constantine. Yeah.
Thank you.
There is literally no information, it seems to me, about this bill, and, relevant parts of the Government of Canada's website have not been updated, it seems, for years. So nobody seems to know what's happening. So one can only conclude, and I haven't heard anything about it, Constantine, I don't know about you, that this is not a priority. Some rumors say, well, now that Quebec has gone ahead, and basically the business world is going, yeah, this is tough, but I guess we can live with it because most of us live with the GDPR anyway, if you do a modicum of international trade. Maybe Canada will just imitate Quebec. Have you heard that, Constantine?
Well, it's interesting. Ontario's consultation paper, which interestingly contained a draft, which is kind of interesting for a consultation paper, was looking more towards Quebec as a model. And I think that's quite indicative potentially. And I think from what I understand that the Western provinces are chomping at the bit to update their privacy legislation. So Quebec may have set the bar for the whole country. And it will be harder, I think, for the federal government to do less.
I totally agree with you. I think they can't do less than Quebec, which will be a bit of a shock, I think, in the federal context, because C11 was nowhere near what Quebec's done. They also have the added challenge to come back to the problems of a federated country, of having to have a much smaller, let's say, playground or sandbox to work in than Quebec does because of division of powers between the federal and provincial governments. So that's a bit of conundrum, I think, for any federal drafter.
And the other issue,
because at the federal level, we are talking about the modernization basically of PIPEDA or PIPEDA, however you want to pronounce it, which does not have an omnibus application across Canada. It only applies to the commercial sector and also not in all provinces, if I understand correctly.
Exactly, yeah. So that's a problem. It's not ideal for today's world, but that's how the world looked in 1867. So,
and this echoes the challenge that our American friends are facing, which is that there's going to be discrepancies between jurisdictions in terms of how they approach privacy. And I mean, one of the key things I think people keep missing out of GDPR is that this was intended to enable the free flow of data within the European Union. And we need to be cautious because we have enough interprovincial trade barriers of not creating more. So there has got to be some leadership from the federal government to, in my view, ensure that we've been really lucky, that we had people like Jenifer, and yes, I do suck up to her frequently, and that we had a consistent approach from our commissioners across the country. Notwithstanding different laws, even legal systems between Quebec and the rest of the country, that the principles seemed to mean we worked out pretty much the same way of doing stuff, which didn't present a huge challenge, I think, to Canadian businesses. And I think that's going to be a pressure now to find that way to ensure that our own common market isn't inhibited.
On the theme that Constantine has just introduced, is the fact that when this bill was first presented before the Quebec National Assembly, it had some very rigid GDPR-like provisions, like you couldn't export personal information from Quebec to Ontario. Now, at some places, you just drive from one province to the other, and you don't even notice except for a sign that you'd be on the other side, and some roads don't even have signs. That's how much of a current barrier it is. But anyway, so you couldn't export data from Quebec unless the jurisdiction to which it was sent was on a list that was drawn up by the Quebec government, that it was equivalent to Quebec's legislation. So this sound familiar? Well, this created a minor storm because people went, hello, how are we going to do this in interprovincial trade, which is a lot of our GDP, internal interprovincial exchanges, as well as the Quebec government is not the bureaucracy at Brussels. How are they going to, assess all of Canada's provinces, let alone all American states, and the U.S. is our biggest trade destination, let alone the rest of the world? The good news is that on this and many other points, the Quebec government, which is quite pragmatic, dialed things back. So they are more flexible. They're more in keeping with Canadian business practices, North American business practices. And so I think that, business will be able to live with it. And as Constantine's pointed out, the other provinces may feel that they're able to follow this because it's not as drastic as the GDPR.
Right. And most of the elements of it go into effect 2 years after it was passed, so September of 2023. Mm-hmm. What are the most complex pieces? Which parts are you afraid may not be able to be followed, or what's going to be most challenging about it?
I'll jump in and I'll say, I think that the main challenge is going to be building up capability within organizations. I mean, I think it's going to be interesting because, by default, the CEO is a privacy officer, in effect. Well,
sorry, what? Can you repeat that? The CEO
yes.
is the privacy officer? Really?
Yeah. Oh, yeah. And so there's going to be, I think, immediately a rush to get people who have some capabilities in this area. Other key challenge, you also, there's plain language reporting for privacy notices.
Excuse me, Constantine, you can delegate that function.
Well, yeah, you can delegate.
You can delegate it, and you can delegate it to somebody outside, like an able lawyer.
Yeah, and absolutely. But it will mean that there's a rush for talent to delegate to, because the CEO does not want this job. The second thing I think is going to be a challenge is that this, it's can't be underestimated the importance of the French language in this context. You have to be able to communicate all of these PIAs, these policies, these plain language notices en français. And that's going to be, I think, a very distinct challenge. Anyone who's dealing with the official languages in Quebec is probably used to this to some extent, but it's just going to reinforce that doing business in Quebec is going to require those language skills.
Mais naturellement, tous les Canadiens sont bilingues, non?
Of course. Je viens d'Alberta, partner.
Pas tout à fait. Pas tout à fait.
For those who don't speak French, I just joked that all Canadians must be bilingual, which is unfortunately not true.
No. Right.
But that also is reminiscent of some of the member states in Europe, France and Germany in particular, insistent on using native language.
Absolutely.
Yeah, because it's only fair to consumers wherever you are, in Italy or Portugal or whatever. You can't be expected, can you imagine, all of us going onto a website and trying to read Mandarin. Maybe some of you do, but I can't. So I think that's kind of normal.
Well, I'm very happy there are people out there making translations for me.
Today's world.
You're more adept at handling them than the rest of us, Paul. But you're going to have a privacy program, and this is something I've always noted. Canadian companies like throwing up the 10 principles on their website, and they think that they're done. And, the radar is going to get lower now, and you're going to actually have a privacy program, and you're going to have to do the things that you actually say you're doing in your privacy notice. So I think that's the challenge across the board whenever a jurisdiction passes a robust privacy law.
Right. And
there's some very, if I can just follow up on that, there's some very different new provisions, too, that if you are going to be tracked in any way, surveilled, you have to opt into that. You will have, like in the GDPR, the right to this. I think this is 3 years out from now. Your personal information transported somewhere else or given to you so you can transport it.
So that's the data portability, right?
Exactly. There's also, to come on to Constantine's point about redoing your privacy management program. This is going to be with some of the features, almost all of the features you have for Europe. For example, notice to people at the point when they become subject to automatic processing. Now, how this is going to work out, we don't know, but I mean, this is a quantum leap in terms of what you demand of your privacy program, I think.
So one of the things I saw in the law is that the Bill C-64 or Law C-64 also allows for a right to be forgotten, or a droit de l'oubli.
Yes.
Would that be just the ordinary right to deletion, or is that similar to the delisting from search engines requirements that we got in Europe following the Costeja case?
Mm-hmm.
It's the delinking, but also coupled with it a right of erasure, because we don't live in a vacuum. We have records retention policies and laws that require us to keep data, but privacy doesn't undermine that. But what it does establish is, when it's no longer required by law for the business purpose, it should, the individual has a right to request its deletion. So it's sort of the two sides of the same coin, Paul, is the right to delisting, which is distinct from the right of erasure.
Yeah, and that is also actually big news, because there are not many laws, including GDPR, that explicitly spell out that right to delisting. So far, it only exists by virtue of court decisions around the world.
And I think one of the most interesting parts of this new law is the fact that they go on to explain this right to withdraw, have information withdrawn. And, they talk about freedom of expression. Yes, thank you, de-indexing. Freedom of expression. And if you're a public personality, this obviously does not apply with you in the same way. What is the extent of the harm that is caused to you? It has to be serious harm. So there's quite a few, I think, thoughtful, modulations of this right to withdraw information. That means that I think that it is quite workable and could, be a measure for good to restrain the worst excesses, perhaps, of the ad nauseum repetition of negative things about people who are otherwise just leading their lives. So we'll see how that works out. But
Well, I had a question, and this is about enforcement in Canada. So, Jenifer, earlier on you mentioned about, and Constantine, you did as well, about a privacy notice that companies are going to have to actually post and abide by what they post. And so here in the U.S., the biggest fear to individuals is the Federal Trade Commission going after companies for deceptive and unfair trade practices by saying they do something they don't, or vice versa. Is there that type of enforcement in Canada at all?
Well, I'll jump in. Today, no. Well, until Bill 64. Bill 64 is going to provide not only for, administrative penalties, but penal offenses and a private right of action. So I think that there's going to be, enforcement. Jenifer can speak much more about the challenges of enforcement in Canada. But one interesting little development was the Competition Bureau, which is our equivalent to the FTC, actually fined Facebook. Now, it was paltry compared to what the FTC does. It was only $9 million, right? Very Canadian. But
Canadian dollars.
Yeah, Canadian dollars even. But it signaled, I think, an interesting direction, because that is the first time they've actually done so, have echoed the FTC jurisdiction. But, Jenifer has much more expertise on the subject of, enforcement challenges. So.
Yeah. Yes. Enforcement challenges. I think first of all, as Constantine has pointed out, the enforcement body in Quebec called the CAI, short form, has huge new powers to impose administrative monetary penalties. There are penal offenses that go before the courts in Quebec and so on. So you can be fined, like the GDPR, up to, in some cases, 4% of your world turnover. Now, in Quebec, which is an economy of small and medium businesses, largely, this created quite a storm. So on a second time around, the government made sure that for small businesses who might have been inadvertently caught up in this, as compared to, shall we say, some hypothetical multinational who was doing this as a money-making scheme, and come to an agreement.
Some sort of meta firm or something.
Something, yeah.
Let's not go there.
You could come to an agreement with the CAI and, basically have a settlement and, promise to do better and, in fact, do better. But these are, world-class enforcement powers now, as well as Constantine said, the private right of action, which comes out of Quebec's civil code. Privacy in Quebec is in 3 pieces of legislation. It's in their Charter of Rights and Freedoms, which applies to provincial legislation. It's in the civil code, which is like just the basic, ordinary, everyday law. And it's also in this new law and its predecessors. So you basically, can't wiggle your way out of privacy violations.
I like the fact that they're going towards pretty major amounts of enforcements, the 2%, 4%. But how likely do y'all think, now that they can't wiggle out of enforcement action, how likely do you think they'll go for the...
Well, Europe's experience may be illustrative in this regard. I mean, it may take a while to gear up. The CAI also has to have the resources, which they've recognized they need to do, right?
True.
And so ramping up is probably going to be a multi-year exercise, just like it's been with GDPR.
I was going to say, and we saw that happen in Europe. Now, it's here to say, as of yesterday, whether or not we'll see that in China. That might be a new world example of what ramping up and enforcement action is going to look like. I was almost afraid yesterday we would already have, 100 actions ready to drop on the table. So that's good. So,
well, maybe they were, but at least they have not been announced. And don't forget, that was pretty much the same in California, where the the Attorney General immediately started enforcing CCPA the week.
Yeah. Which, up until that week, we were all going, will they? Will they not? Will they? Will they not? We don't know how quickly these things will drop. So that'd be interesting. So I know we're coming towards the end of our time. Paul, was there anything else you wanted to ask? Otherwise, I'm just going to ask our guests, what major thought do you have that you want to make sure that our listeners understand about Quebec?
Well, there is one thing in the Quebec law that triggered me, and that is the continuous discussion that we also have about the US, which is the private right of action. And I do believe that it is included in the Bill C-64, in the Quebec law, and that individuals are able to go to court to fight for their rights if there is a privacy violation.
That's right.
Is that indeed the case?
Yes, that is indeed the case. And to add to that, Paul, to add to your interest, Quebec is the Canadian jurisdiction that has the reputation for certifying most easily the, class actions. Yeah, you don't necessarily win them more in Quebec, is my understanding, but because there's a very clear law on it. If you fulfill those criteria, off you go with the class action. So I think that's going to be a bit of a headache for companies to manage, burgeoning class action.
There has been still a reluctance, Paul, for most judges across Canada to actually find in favor in the private right of action because of the need to link to harm. I mean, it's similar to the U.S. in that regard. But I keep looking to see where that line is going to get crossed, where suddenly the floodgates will open in the proper case, because we've had some significant breaches in Canada. And, the more diligent, or shall we say, powerful the law is in terms of enunciating expectations, like Bill 64, I think it gets harder, to wiggle out. It's one thing if it's principles and, there's not maybe defined standards, but now we have some very clear language. So my constant question is maybe not this particular suit, but someday, at some point, there's going to be some, clear proceeding where it just gets certified and results in substantial damages. We're not as litigious as our American friends. We don't tend to...
Is anyone?
Well, yeah, that's a good question. And the tradition, of the commissioners, Jenifer in particular, has always been like, the amendment that she referred to get people to do the right things rather than sanction them. Right. Because that's
the wise people up north.
Well, it's the origin of the ombudsperson model, and I mean, there's obviously the constraints that put on enforcement, but on the whole, that's a healthy approach, I think. And, one worries about the potential, and this came up in C11, when you have a right of action, how does that work together with potentially administrative or penal sanctions? Do you get double sanctioned? So we've got to think about how that works together. But I think that it will also, again, have an impact on a future federal law.
See, that also illustrates the difference between your southern neighbors, is because y'all consider how those might work together. We're all about just slam them. Every direction you can. Civil penalties, private right of action, criminal penalties, just hit them over and over.
What about double jeopardy?
Yeah, exactly. Okay. With that, is there anything that you want to make sure our listeners understand about Quebec's law as we move forward? Jenifer?
Well, they shouldn't underestimate how complex it really is compared to other North American jurisdictions for the moment. So if whoever's running the part that deals with Quebec, let's say North America wide, and they don't really have had to immerse themselves in the GDPR, I think they should really pay attention, because you could get, I don't know what, surprised. And because the law is coming in over 3 years, I don't think that the enforcement authorities or the public are going to be very sympathetic to things like, oh, well, we didn't know, and or we couldn't read French, or, the market just doesn't go for that anymore.
Right.
The regulatory authorities in the government don't go. So I would say, wake up and smell the coffee. This is serious stuff.
I like it. Constantine.
Well, GDPR has come to Canada. And I think that for me, the main message is supply chains. Don't underestimate, as we've seen in terms of how Canadian companies have had to deal with, say, US and EU companies dealing with European data, the impact it's going to have on you doing business if you're part of a supply chain that leads to Quebec. And that, I think, is going to be the most important impact on businesses in Canada or businesses outside of Canada dealing with Quebec. It is going to flow through by contract, regardless.
Yeah. And that's what's caught a lot of people unawares about most privacy laws, is thinking they're not subject to them, and then it turns wham bam in their contracts. They have to abide by them. So those are great points. Paul, anything else?
No, I don't think so. I would say that on that note, we end another episode of Serious Privacy. And thank you very much, as usual, to our listeners for joining us again. Thank you to Constantine and Jenifer for explaining the intricacies of the Canadian and Quebec legislation to us. And we look forward to welcome you back as soon as there is new news from Canada. For those who listen to us, please rate and review our episodes in your favorite podcast app or podcast platform. Join our conversation on the LinkedIn page of Serious Privacy. Just look for Serious Privacy, or follow us on Twitter at Podcast Privacy. You'll find Kay on Twitter as Heart of Privacy and myself as Europol B. Until next week, goodbye.
Bye, y'all.
If you're a data protection or privacy professional, you already know the pressure. Non-stop regulatory change, AI oversight, internal demands, and the expectation to somehow stay ahead of it all. And the old patchwork of tools just isn't cutting it anymore.
No. That's why TrustArc created a modern privacy management platform powered by Arc Intelligence. The TrustArc platform brings your workflows, evidence, research, tasks, and applications all together in one unified and intelligent workspace, so you don't waste time digging, clicking, or context switching.
With Ask Arc, your privacy assistant, you can ask plain language questions about laws, jurisdictions, or even your own program data, and get credible, cited answers based on NIMBY research and more than 1,000 global laws. It's explainable, transparent, and purpose-built for data protection and privacy.
So if you need to add a vendor, create a cookie banner, or start an assessment, quick actions take formally complex tasks, turn them into bite-sized guided workflows to save you time.
It's a platform that thinks like you, works like you, and helps you move faster with confidence, whether you're a seasoned DPO or you're just getting started.
See how modern privacy gets done. Explore Arc at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.